In the previous video, we were looking at something which may be known as the fourth certainty, and that is certainty of conditions. And specifically, we were looking at conditions subsequent and conditions precedent. Now, there may be some situations where we aren't actually too sure whether or not something would fail on the grounds of certainty of conditions, and it may be necessary to look at extrinsic evidence for us to determine whether or not it will fail. So this is what we're going to be looking at in this video, and this is best explained by looking at a case. So let's have a look at Wetuck Settlement Trust from 1978. Now, the beneficiary was entitled to the income of a fund while he was married to an approved wife, i.e. a woman of the Jewish faith. It was claimed that this rendered the trust void for uncertainty on the same grounds as Clayton and Ramsden, which we looked at in the previous video. So it was argued that it was too uncertain to determine who exactly would fall outside the class of an approved wife, and therefore it was felt that the trust should fail on the same grounds as Clayton and Ramsden. And if you don't understand what happened in Clayton and Ramsden, do check out my previous video on certainty of conditions. However, the trust deed also provided that any uncertainty could be resolved by reference to the Chief Rabbi. The Court of Appeal held that the trust was valid. So Lord Denning held that a trust which provided that money was to be left on trust for the benefit of such of the testator's issue who married into the Jewish faith would be valid because the court, or the trustees, was able to ask the Chief Rabbi for advice as to the extent that there was uncertainty about any postulant. Importantly, in this context, the question of whether or not a person was of the Jewish faith was something which could be answered definitively by reference to Jewish law, which has clear rules on who will be considered to be a member of that faith. So this trust is valid because it was possible on its own terms to appoint an expert who would render the class of objects sufficiently certain. Note that the provision that uncertainty could be resolved by reference to an external third party was included in the trust instrument. Okay, it actually said in the trust instrument itself that any uncertainty could be resolved by reference to the Chief Rabbi. There is no general or implied power to refer questions to any third party. Okay, so this case is an authority. It is not authority that you can use external evidence to resolve uncertainty of a condition on any issue. This case specifically had a trust which referenced that external third party and gave that third party the power to sort of be referenced in such circumstances where there was uncertainty. So in Tepper's Wills Trusts, the trust was in favour of the children as long as they did not marry outside the Jewish faith. It was noted that in Clayton and Ramsden, the House of Lords held that a condition that a person should be of Jewish parentage had failed for uncertainty, but that the term Jewish faith was not considered as part of the ratio. This case seems contradictory to the case we just looked at, Tuck's Settlement Trusts, and that is because it is contradictory and it has been decided wrongly. So a gift was to be made to the children so long as they didn't marry outside the Jewish faith. Mr. Justice Scott said that Clayton and Ramsden's ratio did not mention that the term Jewish faith was too uncertain. The court held that the term Jewish faith would not cause the case to fail for uncertainty if the settler was certain what it meant, following a dictum of Evelay in Tuck's Settlement Trusts. The case was adjourned to allow the preparation of extrinsic evidence of what the testator would have considered to be meant by the condition. So the trust here was upheld as the term Jewish faith was certain from the outset. But there are two problems with this judgment, okay? Although it was not part of the ratio, it is clear that a majority of the House of Lords in Clayton and Ramsden that Jewish faith was not sufficiently certain to be a condition subsequent or of defeasance. And it has always been held that extrinsic evidence is not admissible for the interpretation of wills. So although there had been no reference to an arbitrator of the term Jewish in this case, Scott admitted of the testator's own practice as a Jew, admitted evidence of the testator's own practice as a Jew in order to render uncertain what the testator had meant by the term Jewish. And now this is wrong. You cannot accept extrinsic evidence to interpret wills and shouldn't have done. Re-tuck settlement, does not set precedent for this practice. And at the bottom here, we have a quote from Marley and Rulings from 2014. This is a quote by Lord Neuberger. So this is a lot more up to date now. And he said, in the light of the natural and ordinary meaning of those words, the overall purpose of the document, any of the provisions of the document, the facts known or assumed by the parties at the time that the document was executed, and common sense, but ignoring subjective evidence of any party's intentions. So this recent case in the Supreme Court confirms the correct approach in construing documents, In other words, Lord Neuberger is saying that the subjective evidence of any party's intention is not to be taken into account in construing a contract, and the same rule, subject to Section 21 of the 1982 Act, is to be applied to wills. And we're going to look at the 1982 Act now. So this is the correct way of interpreting and construing documents and not taking into account the subjective evidence of the party's intentions. So let's look at the 1982 Act now. And this says that this section applies to a will insofar as any part of it is meaningless, insofar as the language used in any part of it is ambiguous on the face of it, insofar as evidence other than evidence of the testator's intention shows that the language used in any part of it is ambiguous in the light of surrounding circumstances. Insofar as this section applies to a will, extrinsic evidence, including evidence of the testator's intention, may be admitted to assist in its interpretation. So there is a statutory provision on when you can rely on extrinsic evidence, and this is it. So it only applies to wills, but also trusts created by wills. So you can, in some circumstances, have extrinsic evidence to interpret a will and determine the testator's intention. Now, they could have used this in Retepper's Wills Trust if the Act was in effect at the time. The will, in that case, was created way before the Act itself, despite the case being heard after the case's implementation, so they couldn't actually rely on the statute in that particular case. So in other words, this section of the Act means that where there is a will that is where a will is ambiguous, extrinsic evidence of the testator's subjective intention can be admitted. Okay, that is the end of our discussion on extrinsic evidence and our fourth certainty, and actually the end of our discussion on all of our certainties. So in the next video, I'm going to start looking at and exploring the idea of fiduciary obligations and trustees' duties. So this is quite a big and very important topic, so we'll get started with that tomorrow. Anyway, if you have any questions about this video, then please leave a comment below and I'll get straight back to you. And don't forget to like this video and subscribe to my channel. Thank you very much for watching.